Hey there, everyone. How you guys doing? Welcome to Washington Gun Law Live. Special thanks to Daddy Milk Chocolate, who is really beefing it up tonight. So, Daddy Milk Chocolate, thanks a lot for that. We always need a little extra piss in our vinegar, so thank you for that. Hey, listen, I'm going to be looking over here a lot because I got a bunch of questions, and we certainly got to keep track of Daddy Milk Chocolate and all of his colorful comments tonight as well. But go ahead and shoot your questions on over here, and we'll just talk about a lot of things. We do have a lot to talk about, don't we? I mean, we just had a bloodbath of a legislative session. We have the ATF just going batshit crazy on us in all sorts of different things. And so let me get a couple of things out of the way, a couple of big item questions that I've been seeing kicking around a lot, and I want to get those really cleared up. Now, we've done some videos on this stuff, guys, so you can find the videos or you can just listen to me for a couple of minutes here. Let's talk about Senate Bill 5078, the magazine ban. I'm not going to call it a high-capacity magazine ban. One of you viewers really schooled me on that. It was actually really a good point because essentially when we start banning magazines beyond 10 rounds, we're really banning a lot of standard capacity magazines. Now, listen, you guys, me, a lot of other folks out there own dozens and dozens, hundreds, if not hundreds and hundreds of these magazines, which exceed 10 rounds. Are you allowed? Do you have to suddenly stop using those July 1st? Do you have to get rid of all of them and suddenly either plug them or get other magazines for your firearms? The answer to that is no, you do not. Any firearm that you currently have that has a standard capacity magazine that exceeds 10 rounds is perfectly okay. Now, when we go back and we look at the law, what we see is that there's going to be a new section enacted into RCW 9.41 that's going to make that the manufacturing, distribution, delivery, sale, or offer for sale of high capacity magazines is unlawful. What the law does not do, and this is important, what the law does not do is it does not affect the possession. It does not make possession of high capacity magazines unlawful under the law. Now, do I think that the Democrats in this state are probably going to try to push that along somewhere down the road? Yeah, I think if you give them an inch, they will take a mile. But for all of you guys who have been asking about the magazines and do I have to start swapping out all of my magazines, the answer to that question is no, you don't. As a matter of fact, every one of the firearms that I carry, the lowest capacity magazine that I have for any of the firearms that I routinely carry is 12 rounds. So I have many magazines. I'm going to be buying many more magazines. And I do want to remind you guys, excuse me there, that if you guys are going to do what I'm doing and stock up on these magazines, let's go to the local FFLs first. Let's go to those small, independently owned gun stores in your local neighborhoods and communities because, you know, the Bass Pro Shops of the world, the Cabela's of the world, they can just pack up all their inventory, ship it to another state that does allow its citizens to live free like Americans, and it won't really hurt them. But, you know, if you got Joe's Gun Shop in Chehalis or someplace like that, owned by Joe's grandpa, listen, they either have to get rid of that inventory by July 1st or they're eating it. And I know many of you think that these FFLs operate in this big, huge, high-profit business, and that's simply not the truth. They run very similar to grocery stores. They're on a very razor-thin profit margin. So if they end up having to eat this inventory, this could actually put some of them under. So what I really want you guys to do is go out there and buy these magazines from individuals at the small independently owned FFLs. Okay, so that's what I wanted to say first about magazines. Then we're going to get to some of the questions. Now, untraceable firearms, House Bill 1705. I know that is a real cluster, you know what, of a piece of legislation. And I believe tomorrow we have a video coming out that's going to discuss all the loopholes in 1705. I think there are some pretty significant loopholes in 1705, one in particular, actually. And that's the one I'm going to share with you here in a moment. I purposely did not publish that video while the legislature was kicking this idea around. I didn't want to give them ideas of where their statute was all screwed up. But here's the thing. We believe that an untraceable firearm would be any firearm that was not traceable because of a serial number, okay? And that is partially true. But when we take a look at the current definition found in 941.010, and we take a look in what's proposed in the Senate bill itself, 1705, and the new definition of untraceable firearm. An untraceable, and I'm going to actually pull it out so I can read it to you, but an untraceable firearm has a very specific date to it. And if it doesn't fall within this chronological restriction, then the law actually does not apply to it. So, and I want to make sure I get the language right here so that you guys all get it. We're all talking the same thing here. So a untraceable firearm is any firearm which cannot be traced. Here we go. Untraceable firearm means any firearm manufactured after July 1st, 2019 that is not an antique firearm and that cannot be traced by law enforcement by means of a serial number affixed to the firearm. Now, I know that one of you guys is asking right now, well, how do we even tell if that is, how can you tell whether it was manufactured before or after? And honestly, I don't have answers to a lot of these questions. I mean, I see a lot of questions here. How are they going to enforce these laws? Well, that's an excellent question too. How are they going to interpret these laws? Hell, if you guys watched the legislative debate on the night that this stuff was being passed, the legislators who drafted the statute couldn't even figure out what the damn thing said. So again, an untraceable firearm is a firearm that does not have a serial number that was manufactured on or after July 1st, 2019. So if you got a couple of untraceable firearms that are 3 or 4 years old, nothing in House Bill 1705 actually applies to that, okay? Now, how do we take firearms, frames, and receivers that do fall under the purview of that law? Those do need to be serialized. Again, that will all be in the video that we're going to post tomorrow. And that has to be done by March 10th of 2023. I know the enactment date on that is July 1st of this year, but the actual date in which you would have to theoretically grandfather your firearms in by taking your untraceable firearms and turning them into a traceable firearm, that has to be done by March 10th of next year. Can you just do it yourself? No, you cannot. When you see the video tomorrow, and I won't bore you with all the details, but there's some very specific rules as to who gets to do it and the manner it gets to be done in and the type of numbering that needs to be done. So no, there's only going to be a finite number of FFLs that are going to be able to do it. And candidly, if I was one of those FFLs, I don't know if I'd even want to get involved in that practice because of the liability that it would subject me to or the pain in the ass that it would subject me to with the ATF. So those were the first 2 points that I wanted to bring you up to date. Now, there's a third point I want to make, and then I'm going to start getting to some of these questions. We're going to go for an hour tonight, and if this works out, and let me know if you guys can hear me down there real good in the comment section. I want to make sure that my sound is coming through. But if this doesn't turn out to be a complete unadulterated disaster, then we'll start doing this the first Monday of every month. Okay. Now, I know you guys are going to be asking this question, which is, what are you, Bill Kirk, going to do about overthrowing all of this bullshit law? What are you going to do to overturn this? Okay. And listen, you got to understand what the role of Washington gun law is. And I know I got some attorneys watching online, so they're going to appreciate where I'm coming from on this. I am a trial attorney, okay? I started off as a prosecuting attorney. I had the great pleasure of working for Norm Mailing way back in the day when Seattle was a cool, safe city. And then I had the pleasure of being in private practice ever since that time, over about 22 years now. And so I have spent my life in the courtroom, arguing, litigating cases in the courtroom. When we're talking about constitutional challenges to statutes, what we're talking about is some very lofty arguments that need to be made by appellate counsel. And appellate counsel are different than trial attorneys, okay? And it is really like if you needed heart surgery, you wouldn't necessarily go and hire one of the best brain surgeons in the world to do your heart surgery. So am I going to be working very carefully with any organization such as the NRA, the Firearms Policy Coalition, Washington Gun Rights, any other of the organizations who may be mounting challenges? I most definitely will. Am I personally going to be named as a lawyer on any of those. That is highly unlikely. That is not necessarily what the purpose of Washington gun law is. Do I support any of this legislation? No, I don't support any of this legislation. It's all crap. The magazine ban is absolutely ridiculous. It is an absolute pile of crap legislation. And I certainly hope that there are successful constitutional challenges. But here's the thing. If you think that we are going to have any kind of successful challenge to our state Supreme Court, well, then you just don't know our state Supreme Court. State Supreme Court justices run on statewide elections. Those statewide elections come out usually with the same results as all other statewide elections, which is one candidate with a D next to their name will end up with most of the votes in King, Pierce, and Snohomish County and thus carry the state. Now, judges run nonpartisan races, but between that and then, of course, anytime there's a vacancy on the Supreme Court, the governor of the state gets to appoint a new Supreme Court justice. So considering that the Democrats have been in control of the state for about 40 years now, you can imagine what the political makeup of our state Supreme Court is. You could understand what their views would be on your right to protect yourself, and the likelihood that they're going to overturn any of this legislation is incredibly remote. Do I think it should be overturned? I most absolutely do think it should be overturned. In fact, I was meant to start with this, you guys, but I get this all the time that shall not be infringed, shall not be infringed, shall not be infringed. And listen, I believe in all of that. I believe in all of that. We need to take a look at the language of our Washington State Constitution, Article 1, Section 24 of the Washington State Constitution, because I think in many ways this is even more strongly worded in favor of our individual right to keep and bear arms, because the Washington State Constitution, Article 1, Section 24 says, the right of the individual citizen to bear arms in defense of himself or the state shall not be impaired. But nothing in this section shall be construed as authorizing individuals or corporations to maintain or employ an armed body of men, which means we can't have militias in this state. But the very first section, the right of the individual citizen to bear arms in defense of himself or the state shall not be impaired, not infringed, actually just merely impaired. And this has no condition precedent, unlike some of our so-called legal scholars who believe that the Second Amendment has a legal precedent, which is you have to have a well-regulated militia in order for the individual to have the right to possess arms. It's total ridiculous interpretation, but I think that the good folks who drafted the Washington State Constitution clearly knew what they were talking about when they drafted Article 1, Section 24. So those were some of the comments that I wanted to bring out here, and I'm going to kind of go up over here real quick and take a look at what do we have in the way of questions. And if you guys got some questions, this is the time to start firing them out. While we're doing that, let's talk to Nasu4729. Can you gift a handgun to someone who is older than 18 but younger than 21 if they're an immediate family member? Yes, you can. And actually, I believe it's 941-145. We do have a video on that. There are limited circumstances in which people between what I call the age of purgatory, between 18 and 21, you're old enough to die for the country. You're not old enough to go get a beer. But yeah, there's actually limited circumstances under which they can possess handguns and even semi-automatic rifles in some capacity. So that's a good question. Uppers are not considered the gun. It's lower from RJ. That's true. If you guys want to talk about what's going on, we did a video on this. And as you guys know, last year, since we're talking about uppers and lowers and all that stuff, last year we heard word that the ATF was going to start cracking down on AR pistols, that they were going to try to start reclassifying many of them as SBRs. And for those of you who have been following the solvent trap fiasco and what's going on with the Form 1s, which we could talk about tonight also, you will know that the ATF is pardon my language, but they're kind of a horseshit organization, okay? And they literally move the goalpost every day. It's ridiculous. But we did do a video, and this was discovered by the Firearms Policy Coalition, which I think is a very reputable source here. But they had intercepted some inter-office memorandum amongst ATF, which shows that in this summer, later this summer, the ATF is going to have a significant enforcement effort on that new 4-point scale as it relates to your AR pistols. And we did a video on that, and you guys can search that out. It's called What is the ATF Trying to Do with AR Pistols? And we actually talked to our good friend Aaron, who owns 3 Aces over in Spokane, fine gun stores. Hi to everyone in Spokane right now. It's where I got to go to law school. I love it over there. But basically, it's a 4-point system, and if your AR pistol scores 4 points or more, it is no longer considered an AR pistol. It is instead an SBR, short barrel rifle, and you'll need to pay a $200 tax stamp. Now, we could do a whole hour talk on all of that crap, but what it really comes down to is anything in the configuration of the firearm that is going to make it more likely than not that the firearm is meant to be shouldered is going to rack up points and get us to that SBR range where you're either going to be paying a tax stamp and waiting for the ATF to pass their blessings, or you are going to be a felon. So those will be your two choices. All right, I'm going to go ahead and take a look at some of these questions here. You guys go ahead and keep firing them in. I had a question earlier about concealed carry and whether or not, what exactly are the rules on concealed carry as it relates to a firearm in the car. So let's go over that again real quick. First of all, we can only have a loaded firearm in the car if we have a valid concealed pistol license. If we are carrying the firearm loaded in the automobile, the firearm needs to be one of 3 things, okay? It needs to either be on our person at all times, or it needs to be in the car with us present at all times, or if it's left unattended in the car, it has to be locked in the car. That means the car has to be locked, and it has to be concealed from view to the outside world. So I carry mine when I'm driving in a center console holster. And if I was, for example, going to go to one of the courthouses where I don't feel the need to carry it to the security, which would be any courthouse that's not in downtown Seattle, then what I would do is I would leave it in my center console holster. If you walked by my car and looked in, you would not know it's there. So again, it's got to be on your person, in the car at all times, or in the car at all times with you, or if you leave it unattended, locked away and concealed from view. So that's what you guys need to know on that. Captain Ebola 217, great name. Do I got to do any paperwork to get magazines grandfathered in? Okay, well, so the original bill 1705 had this crazy clause in there where you could presume that you possess those magazines, or you would have a burden of proof, I should say, of showing that you possess those magazines by showing photographs of you with those exact magazines and being able to prove that the photograph was taken prior to the enactment of the law. It was comical. I had a lot of fun with it on one of the videos that we did, but that was taken out in the engrossed substitute bill. So the bill ended up actually getting shaved down quite a bit from the original bill. So for those of you who this is the first time you had to watch legislation being made, and it is true what they say about law. Law is a lot like sausage, which is if you like it, don't watch it get made. But as you know, in our legislature, we got 2 houses. We got the House, we got the Senate, and they will both have bills. And the bills need to reconcile with each other. So if the House passes a bill that's got sections 1, 2, 3, 4, and 5 in it, and the Senate passes a bill that's only got sections 1, 3, and 4 in it, then the 2 houses are going to have to reconcile that bill before it can be sent to the governor for signature. And what happened with 1705 is that the version the House passed and the version the Senate passed was different. And when they reconciled it, the whole take the photographs and grandfather your way in that way was taken out of the statute. There is no way to prove that you actually had these magazines prior to the enactment of the law. I candidly do not know how law enforcement is even going to attempt to enforce this, or if they want to enforce it. You have to remember that on Senate Bill 5078, There was not a single law enforcement agency in the state of Washington, anywhere, municipal, county, state patrol, any law enforcement agency anywhere in the state of Washington that endorsed Senate Bill 5078. In fact, one of the most vocal critics of the bill during the public hearing was Spokane County Sheriff Ozzie Knezevich, who, that guy's a rock star. He did a great job. So there's my little spiel on that. Okay, how about sharing magazines and a ranger while out shooting? Listen, the video that we're got coming out in 2 days called The Good, the Bad, and the Ugly on Senate Bill 5078 is a video I want all you guys to watch, not because I'm trying to draw traffic to the channel, but because I think there's some really valuable information in there. Because the ugly part is this, is that even though the law does not make possession of magazines legal or unlawful, I should say, it does make the delivery of magazines, or I should say the distribution of magazines, illegal. Now, when we take a look at how distribute or distribution is defined now in RCW 9.41.010, it uses the term delivery. Now, do you think that the statute anywhere in the RCWs has defined the term delivery? Well, the answer is yes, it has. I knew this off the top of my head because at one point as a prosecutor, I prosecuted drug cases. And in Title 6950, that's where we got all of our narcotic laws. And yeah, delivery is defined in there. Now, they use the term substance, but substance is a contraband. Apparently, so are high-capacity magazines now. And so merely to give something, to loan something, to give it to them without an exchange for anything else, whether you have an agency agreement or not, basically to hand something to somebody, that can be considered a delivery, which could be a distribution. And so my problem is, and this question was asked, and I think it was a really, really good question is, hey, if I'm at the range and I hand my brother-in-law a 15-round magazine, or I let him shoot my fully loaded handgun that has a 15-round magazine, am I violating the law? Well, the way the Democrats wrote this legislation, technically, yeah. Now, would that be enforced that way? I doubt it would be enforced that way. Certainly nobody at the gun ranges are going to be ratting people out because we all know where they come down on this particular legislation. They're certainly not in support of it. So that's what you need to know. And this is going to obviously be hashed out in the courts. Could this statute be struck down for being overly broad, constitutionally vague? It's possible. I think you're going to need a federal court to overturn it, though, because I don't see our Court of Appeals, and I certainly don't see our state Supreme Court overturning any legislation which was basically trumpeted by Attorney General Ferguson. All right, Sean Jarvis, can you still carry them? They never answered this question. I got to figure out what that question is, Sean. If you can go ahead and shoot it back to me here, then I can take a look at it, and I will get you that answer. Can I, the balls and exotics, great, best name of the night. Can I deer hunt in Washington with an AR platform so long as it is chambered in legal caliber? Yes, you may. Yes, you may. So an AR-10 chambered in 308 or something like that would be perfectly fine. It does have to be 23 caliber or greater to hunt big game in Washington. That's a good question, though. And by the way, we got an interview coming up with Captain Anderson from the Department of Fish and Wildlife. We're going to do that next week, and that's going to be about when you get to kill wild animals in self-defense. And then Wednesday, and I don't know when I'll get this actually posted online, we're going to be doing an interview with Loren Culp, who, as you know, is running for Congress over in Eastern Washington. Now, he's running against an incumbent Republican who's in the House right now, but we're going to be interviewing Loren Culp, and I'm going to be excited to get that to you guys as well. All right, Sean Jarvis, you're still trying to figure out, what are we trying to talk about here, Sean, with the concealed carry? Okay. David White, if you have 80% lowers that aren't put together but have been milled out, are those okay to get serialized? Yes, they are. Go ahead and get them serialized if you'd like. All right. Next, Jesse L. Nick's denied my AR-15 lower, but then 3 days later, my pistol was approved for pickup. Do I still need to appeal with the FBI? Yeah. If you're getting denied and you don't think you should be getting denied, you absolutely need to do an appeal with the ATF. You can do that on your own. You can. I've done a few of them. And as a matter of fact, we can probably do this here. Let me do this real fast. I'm going to actually put the link for how you do the appeal right here into the chat feature. And there you go, man. That's how you do an ATF appeal. Well, that's how you get the paperwork to do an ATF appeal. So, Vills 83199, your thoughts on using a serialized 80% build or using one in self-defense situation? Keep in mind, this is not an issued serial number, but just one that is made up out of the air. Okay, well, obviously, if we end up in a lawful self-defense shooting situation, whether we lawfully pulled the trigger or not, we know that gun is going to be taken into evidence. It's going to be examined. And if we have issues with serial numbers, if we have an untraceable firearm manufactured July 1st, 2019 or later, then we could certainly have some issues. If you guys take a look at House Bill 1705, take a look at Section 6 of that proposed bill that passed, and that will go through all of the things that an FFL has to do to properly serialize what is right now considered to be an untraceable firearm. All right. Sharon Smith, this is an interesting question. So, strange question. How does a gun in the car without a CPL if you're living in your car? There is case law that came out of the Supreme Court that dealt with RVs. There is no case law that necessarily mentions cars that are being used as a home. I think that right now the statute as written, RCW 9.41.050, makes it very clear. The only way you have a firearm loaded in the automobile is you have to have a valid concealed pistol license. So that's the best advice I can give you on that. Jesse L., if you forgot to mark that you were a U.S. citizen, yeah, that could be the problem. Just like all you guys who may have restored your firearm rights from old felony convictions, if you go to 4473 and you answer any of those questions in Section 21 the wrong way, the sale's over. That's it. They're done. You're done. So, if you smoke weed, you might not want to brag about that to the good folks at the FFL. Yeah, okay. Google sucks. True. And good question. When do city police, county sheriffs, state patrol, and the National Guard in the state need to give up their magazines? Well, the answer, of course, is never, because there are exceptions written into 5078 for the military and law enforcement. And I do find it mildly odd that the same political party who wants to defund the police is perfectly comfortable leaving weapons of war with law enforcement, but they need to take them from all of you lawful and responsible gun owners. Nate, just don't smoke weed while filling out 4473. Yeah, if you can wait until you're done with 4473 and then go smoke the weed, that would be definitely the way to do it. Okay, what's Form 1 for making an AR SBR to a pre-existing AR? So, Spencer, what you got is, let's say you have an AR, it's got a 16-inch barrel on it, you got a 16-inch upper, you want to drop down to a 10.5. You go ahead and buy the 10.5-inch upper. You've got to then go to an FFL and start your Form 1 paperwork, because you're actually building an SBR. If you were just purchasing an SBR, you'd fill out a Form 4. Once ATF is approved that paperwork, then you can assemble your 10.5-inch upper with your lower, and away you go. Now, listen, while we're on the topic of NFA items, and I know I got a bunch of questions here, and I apologize to all of you who I'm not going to get to all the questions tonight. We got a ton of questions coming in, and I'm trying to weed between those and some of the very funny comments, and then, of course, we still got one listener who's really salty tonight. So we're just going to have fun with that. But listen, when it comes to NFA items, okay, what's an NFA item? National Firearms Act, okay? These are items that we have to get the federal government's blessings before we get to possess them. Short-barreled shotguns, short-barreled rifles, automatic weapons, silencers, and other destructive devices. Now, when it comes to these items, you're going to get, and I see this a lot with silencers or suppressors. Oh, I got to get a gun trust. I got to get a gun trust. I got to get a gun trust. Okay. And we're going to do videos on gun trust probably this summer when the legislature and the ATF kind of chill out for a while. But here's the thing you need to understand. Do you need gun trust? Yeah, I think there's reasons to get gun trust. And candidly, if Senate Bill 5217, that AR ban, had gotten through, there would have been a need for all of us to get gun trust. So you want to be carefully watching that stuff. But if you're going to try to accumulate items, NFA items, into a gun trust, it's going to take forever. It's going to take like a year's worth of paperwork. If you want to actually get the items, use them, have fun with them, and stuff like that, the best thing to do is to accumulate the NFA items as an individual, establish a trust later, and then transfer the items into the trust. It might cost you a few dollars extra to do it that way, but it's going to save you all the waiting time and all of that stuff. And clearly the ATF is very carefully scrutinizing, especially Form 1s right now. So I think that they would be even more scrutinized if it was being done as a from a trust. Nicholas W., from what I had read, large capacity magazines must be locked in a box, unloaded, separate from the firearm to be transported out of the home. Does this mean you can't conceal carry with more than 10? Nicholas, you may be late getting here, and I'm not being a sarcastic dickhead here, okay? I mean, you may have been late getting here. We talked about this already, but whatever your personal carry firearm is, and anyone who's joining us late, if you got your standard, one of the firearms that I carry very frequently comes with a 15-round magazine. And when I carry my subcompact, it's still a double stack. I don't like single stack guns in my hand. They just feel a little too snappy to me. And so I carry a double stack. That's 12 rounds. I do not, but no, I take that back. I do have a couple of firearms that have less than 10 round capacity. I candidly don't like them, and I haven't shot them in a year or more because I just don't like the single stack guns. That's my personal thing. So whatever your personal carry choice is, yes, you can carry with that magazine. The possession of high capacity magazines is not unlawful. I'm not defending the law. I still think the law is a pile of crap, but I'm telling you what the law actually says. Okay, Jake. What if an individual works at a cannabis farm but doesn't consume or use cannabis? My first question would be like, why the hell are you working there then? Still good on the 4473 11C, correct. Jake, here's the thing. If you admit that you're using marijuana, whether you're using it or you're not, okay, if you answer that question in the affirmative, that's the end of the sale. The sale's not going through. Am I encouraging people to go lie on their 4473s? No, I'm not encouraging you to do that. I am telling you what happens if you answer that question in the affirmative. You would be the first person in the history of the industry to actually work in the industry and not actually, sample the products. Okay. Observationist question: is the ATF about to start requiring FFL serialization of uppers and require NICS checks for AR and AK uppers? No. Upper receivers, well, okay. Currently, upper receivers do not constitute a firearm. It's just chunks of metal, okay? The lower receiver is what's considered to be the firearm, and that's the part that would have to be serialized. Now, is it possible that the ATF could change their interpretation of the law? Well, if you've been watching what's been going on with suppressors and silencers lately, yeah, that is entirely possible. Absolutely it is. Because again, that law enforcement agency it's a clown show, and they constantly are moving the goalposts. But right now, there's no requirement that your uppers be serialized or anything like that. No matter what platform you're buying your upper receivers for, knock yourself out. Lower receivers is a different story, especially once 1705 is fully implemented, March 10th of 2023. Okay, Ave Imperator, talk about concealed carry insurance ban. I'm going to make this quick. I really don't like talking about this too much, but I am going to give you a truthful answer on that, okay? Attorney General Ferguson, a number of years ago, came out and said, it's murder insurance. We're not going to allow for this in the state of Washington. And he did a very good job of labeling. And I got to tell you one thing, that the political left is a little bit better at labeling than the political right. Candidly, it's about the only thing the political left is good at is labeling. But, ghost guns. I mean, wow, what a scary term, high capacity magazines. I mean, they really do a good job with that. And so with this particular issue, what we're let me go back to the question here real quick, because I want to make sure we answer it exactly the way you asked it. And now, of course, I can't find it. Oh, yeah. Okay. So what happened is that a lot of people think that the Attorney General came in and just banned concealed carry insurance. Like somehow or another, they passed a bill in Olympia that said it is not permitted in Washington State. And that is not what happened. What Attorney General Ferguson and Mike Kreidler, who was at that time the insurance commissioner, did is they just rewrote some regulations in the WACs and basically made it impossible for any of those companies, as they were currently structured in the state of Washington, to continue to conduct business. So all of them essentially were taken out of business for roughly about a year. Now, when they rewrote the WACs, when the Insurance Commission rewrote the WACs, they put a roadmap right in there, like you can't come back in this state and do business unless, and they listed all of the things. And one company has successfully jumped through all the hoops, and they are doing business in the state of Washington. That's U.S. Law Shield. Now, that's all I'm going to say about that. U.S. Law Shield, I know for a fact, is doing business in this state. And if you want to contact them, please Google them, contact them, talk to them, ask them the tough questions about this, okay? Because I know a lot of people are very leery about this, and it's too good to be true. And I want you to have those conversations with the folks at U.S. Law Shield. So that's uslawshield.com if you want to look it up. Do polymer, poor twisted me, do polymer lowers in sidearms like Walther, Sig Sauer, and Canic have to be serialized? If they were made after July 1st, 2019, they will as of March 10th, 2023. Angry Lion, you still did not answer the question. Can you conceal carry with more than 10 rounds after July 1st? Angry Lion, quit being so angry. Yes, you can. If you have a firearm right now, currently, or you buy one before July 1st, and it has a standard magazine of 17 rounds, great, you get to carry 17 rounds. You can carry any magazine you want. The law does not prohibit the possession of high-capacity magazines. It does prohibit the commercial sale of them. And really, this is a bill that was meant to attack the FFLs. Now, again, it attacks all of us, and I'm not watering this law down here, okay? This is serious stuff here. And candidly, we all think it's a bunch of BS. But this was definitely meant to hurt the FFLs and to prohibit the commercial transaction. So, Angry Lion, if you got 10 rounds, 12 rounds, 15 rounds, 19 rounds, I don't really give two craps. You get to carry it, okay? John T. Starr, what's your thoughts on FRTs, the forced reset trigger? Listen, this is a big issue. Now, right now, if you try to go buy a rare breed trigger to Washington, the rare breed website will tell you that they're not shipping to Washington State. And we've done a couple of videos on that, so check them out. But it is absolutely for certain that the ATF has deemed the rare breed forced reset trigger to be a machine gun. That's right. A trigger now constitutes an entire machine gun. And they are absolutely positively going after that. They're going to be going after the FFLs first. They're going to be getting all the shipping and sales records, and they very well may be going after individuals. If you have a forced reset trigger, you need to be aware of that. You might want to contact me privately. You also might want to check out the videos that we've done on that topic. We've done, I think, about 3 different videos on that. But yeah, that's my opinion on the FRT. Sydney L., good question. Can magazines be inherited by my family upon my passing? Well, first of all, Sydney, we hope that day is a long, long way from coming on here, okay? But what I would say to you is that, yes, they could be. Well, legally speaking, if we take a look at the law, that would probably be considered a distribution, and it probably would be deemed unlawful. Now, if my uncle passed away tomorrow and I suddenly inherited 7 different firearms, I would be okay because this would all have occurred prior to the enactment of the law. Again, how is law enforcement or everyone ever really going to be able to tell when you came into possession of the firearm? They can do that because they can take a look at the sales date, at least when the original owner purchased it, if it was purchased in Washington State. The magazines, I mean, I have actually purchased magazines for firearms that I did not yet own. Okay, so some of you may be doing that right now too. You know you're going to get one. You can't find it. You can't find it at the right price, but you know you load up on some of the accessories to go through it. All right, that's Angry Lion. He's hopefully not as angry anymore. The Alex Ayala, does 5078 prohibit the purchase of magazine extension plates? Now I'm going to be a little naive here. I'm going to actually have to take a look at what is a magazine extension plate. If a magazine extension plate just merely extends the magazine, so for example, let's say, yeah, it looks like it does. That's exactly what it does. I hadn't heard that term before, but thank you for that. So yeah, if you got a firearm, kind of the subcompact, where maybe your bottom two fingers are hanging off the handle, I don't like that at all. I like to have a full grip on the firearm, and you get a plate, so there's a little extra spot for your pinky to go. There's nothing unlawful about that because you haven't changed the capacity size of the magazine itself. You may have changed the length of the magazine, you may have changed the ergonomics of it, made it a better fit for your hand, but you haven't changed the capacity, so that's not going to do it. Benito Acervanza, buying mags before I have an AR. Why not, brother? Do it. Zach Whitney, is this a federal ban on 80% lowers? No, and there's a few other people on that. But listen, I did a video on this, and there are some areas that the ATF is currently going batshit crazy over. Okay, they're going crazy over the FRTs, the rare breed triggers, and things like that. We know they're going completely crazy over these Form 1 kits, suppressor kits, and things like that. They're rejecting, I think just last week, I got an article actually right here from NRA, Independent Legal Analysis, and there was something like 2,000 rejections in one day last week, and I ended up doing a video on it. I want to thank a couple of my viewers who tipped me off on that, so I really do appreciate that. So anyways, that's what's going on. So we got them going after the FRTs. We got them going after the suppressors. We got them going after the SBRs. So yeah, I do think that and we're seeing now proposed regulations published in the Federal Registry about unfinished frames and receivers. And shockingly, when you take a look at what's coming out on the federal level and what you see what's coming out of the state of Washington level, they literally mirror each other. And if you take a look at the federal guidelines for trying to get red flag laws in all states nationwide, the red flag laws that the federal government is proposing as a model is literally a verbatim copy of what we currently have here in Washington State under RCW 7.94. So there's no doubt that Attorney General Ferguson and Attorney General Garland back in Washington, D.C. are two peas in a pod. Benito, you're moving to Arizona in 45 days. Congratulations. You'll get to live free like an American. Us in Washington, we remember back in the day when we too used to get to live like Americans. Red flag laws. Yeah, let's talk about red flag laws. Red flag laws is a very controversial subject. I have done a lot of red flag hearings. Red flag laws in Washington State are found in RCW 7.94. And what essentially a petitioner needs to either be a family member or law enforcement agency, and the petition needs to state that you pose a threat to yourself or others, and you have access to firearms. If the court believes that there's sufficient evidence to warrant a full hearing, they would set a temporary order, thus forfeiting your firearms temporarily, ex parte communication without you having a right to even hear anything, for a minimum of 14 days until a full hearing is conducted. Once the full hearing is conducted, the judge would then determine whether or not a full order is issued. If it is, it's issued for 1 year. It can be renewable after that 1 year. Now, the crazy thing about these red flag hearings, and this is the thing that just gets me to pull my hair out on this stuff, is that everything can be done through petition. So, you can have a really super pissed off ex-spouse who's making up all sorts of crap and just spew all sorts of stuff onto a paper, and that would serve as the petition. Now, do I, if I'm representing the respondent, do I get an opportunity to cross-examine that petitioner and kind of assess her credibility and test the waters? No, I don't. Because it's all done through writing. So we can file our own petitions, our own declarations that say, hey, she's full of crap, but it's a piece of paper against a piece of paper. So this has been, it's been a very frustrating thing. My two most recent red flag hearings, just to give you a couple war stories. The first one was the Seattle Police Department actually going for a red flag order against one of their own, a Seattle police officer. We prevailed on that one. I had another one in Edmonds that I think we were going to prevail on. In fact, we were knocking the prosecutor around so bad that they asked for a recess on the hearing to adjourn 2 weeks later. I objected, but the judge granted it. And in the 2 weeks, my guy got charged with unlawful possession of a firearm. So that pretty much ended our chances of actually prevailing on that one. Salmon Boy 2692. All gun sales after July 1st will be guns that can only hold 10 rounds, correct? Yes. And that's a huge problem for the FFLs. A huge problem. One of the 21 amendments that was offered to the bill was one that would exempt magazines that just came with the firearm, right? Your standard magazine is 17 rounds, comes and say, you're good to go. And the Democrats rejected that. In fact, of the 21 amendments that were offered, only one of them came really close to passing, and that was a proposal to raise the limit to 15 rounds. Now, Brad Clippard out of Pasco or Kennewick, one of the three Tri-Cities over there, but Brad Clippard, who is a huge supporter of your Second Amendment rights. So please remember that. Please make sure you always support Brad Clippard because he really has gone to bat. He had a proposed amendment that was going to go to 15 rounds, but then there was a Democrat out of West Seattle who proposed it. And to her credit, and I can't remember her name off the top of my head, it has a hyphenated last name. To her credit, she had gone out and actually talked to her community, and many lawful, responsible gun owners in the community had explained to her the fact that, 10 rounds really eliminates a lot of standard capacity magazines. And so she proposed that it go to 15, and it failed by 2 votes. It failed by 2 votes. 2 votes the other way, and this piece of crap legislation would still be a piece of crap, but it wouldn't be as crappy, okay? Yeah, Krinkov, so they can't even sell a Glock 19 without a mag. Well, they can't. I mean, they sell Glock 19s in California, too. I'm not saying that, oh, hey, they can do it in California, we can do it here, because candidly, I think if you're aspiring to be California, you're not aspiring to the right things. But yeah, I mean, these firearms manufacturers do make 10-round magazines for states that don't allow their citizens to live free. Difference made. Are these bills vulnerable to legal attack for shifting the presumption of innocence to guilty until proven innocent? No, I don't think they are, because I don't think the bills do that. And maybe that's your interpretation, and I'm not saying you're wrong. I don't interpret it as that way. I really don't. I don't think there's this presumption of guilt. I don't think there's a shifting of a burden. But that's on its face. There are 2 ways to constitutionally challenge statutes. One is on its face. Okay, you look at the language of it, and you're like, and Corey's Corner. Thank you, Corey's Corner. Yeah, it was Harris Talley, Representative Harris Talley out of West Seattle was the Democrat who proposed that. So thank you for that. But when we're challenging, getting back to the other point, when we're challenging statutes on a constitutional level, on its face challenges, hey, we just look at the words and it's screwed up. It's not going to fly. Then we have what's called in-application challenges, which is on the face, the statute seems fine. But once we see the law implemented, once we actually see how the law is used, there can be constitutional concerns there. Are there going to be challenges to these laws? You better believe it. Are they going to be successful in Washington State? I don't believe they are. And it's not because I don't believe the challenges are without merit. I think the challenges have excellent merit. I just don't think you're going to get anywhere with this state Supreme Court. Now, on a side note, we know that the United States Supreme Court is sitting on a landmark decision in the New York Pistol and Rifle Club v. Bruin. And the question framed to the court is, does the Second Amendment guarantee the right to possess a firearm outside of the home? Right? We all think about it, it's like, well, of course it does, right? Well, not so much in New York City. That's not the way their laws work there. Not so much in California, actually, either, too. I have no doubt that it will be a good day for the Second Amendment when that opinion is published. But what really I want to see is will the Supreme Court take this opportunity in dicta to write other powerful statements about how far our Second Amendment rights go? Will they allude to the fact that magazine bans, AR bans, other types of bans, ammunition bans, things like that, are infringing upon a person's Second Amendment, and telegraph to litigants that maybe the time is right for these types of issues to be brought before the Supreme Court? The Supreme Court of the United States, for those of you who don't know, they don't have to take any case. They literally do not have to take any case. You have to apply through a certiorari, a writ of certiorari to the court, say, please take the case, please. And they have been very hesitant to take Second Amendment cases for about 13 years now. The last major decision was the Heller decision, and that clearly established our right to possess a firearm within our own home. Bruin is going to go much farther than that. Now, there are some other cases, including a magazine ban out of the Fourth Circuit that's working its way up. And so I do think that if ever there was a time for us to get issues before the United States Supreme Court, it's now. I know that we have Justice Breyer retiring, and we'll be replacing it likely with Justice Brown Jackson. I do believe she will be appointed, but that's not going to change the conservative liberal ratio on the bench. So it still is what's theoretically considered to be a 6-3 conservative majority. I think it's more of a 5-4. I think Justice Roberts has proven to be quite the swing vote on a lot of issues. So I don't think he's as conservative as perhaps President Bush thought he was when he actually appointed him. Ruben, off subject, bought 2 firearms the same day. A rifle and a shotgun was approved. Oh, the rifle and a shotgun. Shotgun was approved. Rifle was denied. Well, I can't understand why one would be approved and one would be denied. I can understand how you would have one approved and a delay on another one. In fact, the last 3 or 4 firearms that I purchased, I've had delays on, 2-3 extra days. If you've actually been rejected, you might want to give the office a call and we'll figure out what's going on there. Wade Graham, how will AR uppers, stripped or completed, work with 1705? 1705 has no bearing on uppers at all. There's nothing, they didn't add a definition of upper receiver, upper frame, anything like that. So it only deals with unfinished receivers, untraceable firearms. It does not deal with anything involving the upper part. The bird brain solvent trap update. Oh God, the freaking solvent traps. Real quick, as a side story, last year in August, I did a video about, hey, are suppressors legal in Washington State? I was just kind of feeling out the YouTube thing, and I was like, that's a good topic. Okay, so I did a little research, Googling around on suppressors and stuff. And even though I'd shot guns for years and years, and I at that particular time we were in the middle of the pandemic, but at one point, right before the channel got going, I was running about 500 to 600 rounds a week downrange. So, but I'd never shot a suppressed firearm. It was just something I'd never really gotten myself into. So I did this research. And then the next couple of days on my freaking Facebook page, I'm getting inundated with this solvent trap, and I'm looking at all these ads and it's always a nudge, nudge, wink, wink, hey, it's a solvent trap, right? And so I ended up doing another video in August of last year that was kind of like, hey, these solvent traps, don't be turning these things into suppressors. You're going to get in trouble unless you're doing a Form 1. Well, fast forward, all of a sudden in January, I take a look at the analytics on my channel and I see those 2 videos taken off again. I'm like, what? They didn't do that good the first time. Why are they doing good now? And that's when I started researching this stuff and I started getting calls from people about the diversified machine and things like that. Listen, the problem with this whole solvent trap crap, okay, is that it's got the ATF so spooked about everything that now they're taking these Form 1 kits from very reputable manufacturers and they're rejecting that. I mean, we had like 1,000 Form 1 rejections, and I'm questioning whether or not Form 1 is basically going the way of the dodo bird. Is it extinct? Is it we're not going to ever use Form 1s? Because right now the ATF is saying, listen, any parts designed to be put into a suppressor, we're just going to include it. We're going to count that as a suppressor as it sits right there. And therefore, you got to fill out a Form 4. Form 1 is wrong. The other thing, and this is what spooks me, and again, we've done a video on that, and go ahead and take a look at that one too, is what they're claiming on this stuff is they're saying, hey, listen, it said in your Form 1 that you were the person that was going to manufacture the suppressor, because that's how it works when you fill out a Form 1. But then the ATF is saying, but you bought a full suppressor, which means somebody else manufactured it, which means you lied on your Form 1. Now, the ATF likes to use scary language. So does the IRS, by the way. But if they were to actually enforce the law that way, okay, all these people who bought these solvent traps, but actually did the one thing that you could actually kind of legally justify, which is like, well, I'm going to mill them out, but I'm going to do a Form 1. I'm going to get ATF blessings. And then once I got ATF blessings, I'm going to do that. That's exactly what you should have done. If those people are subject to criminal liability, we have completely, and I do mean completely, lost our mind as a country. We're down to just the last few minutes, guys. I'm going to try to get a few more questions answered. And listen, this worked out pretty well. As long as you guys can hear me, it hasn't been a complete unadulterated disaster. We're going to start doing this the first Monday of each month. The first Monday of each month. So you guys can go ahead and mark your calendar now that we're going to do our next one on Monday, April 4th at 7 o'clock. So that's going to be Monday, April 4th, 7 o'clock, right back down here on YouTube. Nitro Juga, about the Form 1. Listen, I did a video on that. I don't want to take too much of what few minutes we got left. Please watch the video on that. I'm not a big fan of you sending more information to the ATF. I know a lot of you got this Form 1, not a rejection letter, but well, upon further review, we want more information. And listen, I think if you send them all the information, they're going to reject the damn thing anyways. But I don't like when I see a government agency going completely psychotic right now in their enforcement efforts. It's really hard as a criminal defense attorney to say, I think you should open up more channels of communication with that law enforcement agency. Candidly, I do nothing. I think it's going to get rejected. You may want to turn around and fill out a Form 4. We'll be doing more videos about that. White Tiger Exploration. I bought a G17 for the purposes of a 17 rounds. Shaking my head. Hey, White Tiger Exploration, as long as you take possession of that firearm before July 1st of this year, knock yourself out. In fact, I'd go out and order a few more 17-round magazines to go there. Ranger Prepper. Love that name. Ranger Prepper. Yeah, listen, if you contact us at Washington Gun Law, we can get some of those questions answered for you. Alexander Webb, is it illegal to have 30-round magazines loaded? No. In fact, magazines don't do you any good if they're not loaded. Divinity, what's our best bet for proving ownership of pre-banned mags if they try to take them from us? We could have had photographic evidence. The statute would have actually would have allowed for that. There is no way of actually proving it. I've been kicking around the idea of doing photographic certifications with notaries. Let me know if you guys are interested in something like that, where we would actually take a photograph of you and all your freaking magazines. I'm sorry, I can't keep a straight face. I mean, this is seriously what we've become as a country, is that we're talking about this kind of crap. But we could do photographic and then do a declaration, have it notarized by a notary, and then therefore you could forever memorialize all the magazines you own. It's a service that I can't do for free, and I candidly, the thought of taking money from all of you guys, the lawful and responsible gun owners, makes me just want to beat my head into a wall. So it's probably, let me think about that a little bit more. All right, John Weiser, what happens if I were to sell my firearm post July 1st? Do I have to just keep my magazines that I have more than 10? Yeah, John Weiser, that would be the thing to do, unless, of course, you were selling it out of state, and then I'd just go ahead and do it. Cruel Kilgore, will 80% kits built prior to this new law be legal now? And remember, an untraceable firearm is anything that's not traceable by a serial number that was manufactured on or after July 1st, 2019. If it was manufactured before then, it's not considered to be a untraceable firearm. Alex Mowry, what is your next seminar and where? Hey, that's a good question. I'm coming to Spokane this weekend, okay? I am coming to Spokane this weekend. I'm going to pull up my calendar so I know what the hell I'm talking about. I'm actually going to be over in, I love coming to Eastern Washington. So anytime I get a chance, but I grew up here in Western Washington, but I went to college at Washington State University. I went back over to Spokane for law school. And candidly, if I could live in Eastern Washington, I probably would do that. Okay, so Friday night, I'm going to be at the Well Armed Woman event at the Spokane Rifle Club. That's at 6:30. That's the Well Armed Woman event, Spokane Rifle Club on North Aubrey in beautiful Spokane, Washington. Then on Saturday, I'm going to be out at an active shooter class out in Chihuahua, north of Spokane. Great community out there. That's going to be an all-day thing. And then on the 13th, I'm going to be at the Newport Gun Club at 11 a.m., talking about all of our rights and obligations under Article 1, Section 24 of the Washington State Constitution, as well as RCW 9A.16.020, subsection 3, our self-defense laws. RJ Takazan, UW dogs with an exclamation point. My response is 40-13. You know what score that was. Okay, listen, guys. This was a fun hour. We had over about 530 of you guys online, and that is freaking awesome. Listen, I'm going to get rolling, but I want to say one thing to you guys. Just this past week, we crossed over 23,000 subscribers on Washington Gun Law. Now, we just started this channel last summer. I was in the middle of COVID. I had my long COVID due going, and this has really taken off. And it's really taken off because of all of you guys, okay? I could not do any of this without all of you. So to all of you lawful and responsible gun owners out there, from the bottom of my heart, thank you very much for everything that you've done, for the support you've shown Washington Gun Law. Please keep coming back for more. We're going to be back Monday, April 4th at 7 o'clock. We're going to do this again. I got a bunch of videos queued up that's going to be all talking about legislative stuff until we get to the Sunday video, because then we're going to talk about a topic that you guys have all asked about. I've been too lazy to do that video, but do I have to tell an officer when I get pulled over on the side of the freeway if I'm carrying a firearm? Stay tuned, because we're going to give you that answer on Sunday. In the meantime, listen, you guys all know the drill. The only way to be the lawful and responsible gun owner, like we talk about all the time, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Thank you very much for joining us tonight. This was totally awesome. I can't wait to do it again. In the meantime, all of you guys, stay safe.